Adjournment request, if any, from item number 1 to 6.
Lordship, with the consent of the other side, I beg to mention item number 3. Yes, Lordship. In that the petitioner desires to place on record his pension slips. So I may be allowed 3 weeks' time.
The request will also put the petitioner with this matter in the month of July.
Much.
From item number 7 to 17, adjournment request.
Ay, kami, video na yan.
Lordship, item number 7 may be adjourned for today, as the conducting council left for Delhi yesterday due to some legal assignment.
Practical engineer. What do you? This is a contempt petition wherein you moved an application for implementing somebody.
Yeah, we filed an IA. IA is for the implement of present officer.
So you want adjournment?
Yeah.
Why?
Conducting council is out of station. They left for Delhi yesterday.
4 weeks. And the request is going to 4 weeks. Yes.
Yeah, please, Lordship. Lordship, I beg to mention item number 16 and 17, Lordship, with the consent of the other party. Maxine is currently
Adjourn.
outside. Deeply please.
May I please, your Lordship? Lordship's indulgence, I beg to mention item number 12. So, Lordship, on the last date, Lordship directed me to file the wakalatnama on behalf of the respondent number 6. Now, he had gone someplace visiting, Lordship, and he sustained an injury and fractured his leg. So, he has not even returned home, my lord. I had sent someone.
You can send the.
No, he is not at home, my lord. That is why.
Where is, who is for the other side? Have you informed the other side?
No, I just, it's the court. I'm sorry, Lordship.
Then they're seeking some time.
Lordship, we were not informed, Lordship, my senior.
That's why only we have called you.
Lordship.
They're seeking some time.
To file the wakalatnama, Lordship, he is not at home, my lord. I had sent someone,
You have to file response also. Sir.
Lordship.
You have to file this response to the petition also.
Yes, my lord.
Lordship.
You can learn it consent, waiting for that. Respondent number 6, please. Some more time to file power on behalf of the respondent number 6, as well as counter to the JL petition on behalf of him. When it council appearing for the petitioners. Has no objection. Since this back in July.
I'm highly obliged.
Adjournment request from item number 18 to 29.
Wait, please, Lordship. Lordship, I beg to mention item number 18. I seek an adjournment in this matter. Can this matter be taken up in the month of May, my lords?
Adjourn.
Obliged.
August.
Madam, may I mention, madam?
Yes.
Madam, I'm for the 24, item number 24, madam. Here in madam, I am for the private respondent number 12, madam. Madam, may kindly accommodate me,
August, adjourn.
madam. Deep love blessing.
Adjourn August.
Item number 24. Already mentioned.
May you please, your Lordship, with the consent of the other side, beg to mention item numbers 19 to 23, Lordship.
Criminal slip is circulated on behalf of. With no objection.
Deeply obliged.
Any other request?
Madam, 26 to 29.
Yeah.
We were very happy because this was covered by a division bench judgment relating to venture school. But I am now told that a review notice has been given there. Therefore, I think
With judgment, division bench.
because it related to it related to provincialization of venture schools. Venture schools.
Under the provisions of the Act of 2011.
Absolutely right, Lord. And then The judgment, division bench heard the matter, I am told in very great detail, and a very long judgment given, which has gone in our favor. So I was very happy that I am spared the
That
trouble.
special bench,
Yes.
Yes, Justice Suman Chand and
A.D.
A.D.
Justice
Chaudhary.
Chaudhary.
Yes. So now they have issued a notice for review. Therefore, I think we have to wait a little.
Which judgment, the division bench judgment, which is the judgment?
7955/7.
The title.
Naam to naam.
Naam.
The title of that division bench judgment.
I know, Milord, but he is not remembering. He is thinking
Some
mobile.
Monisali something. like this.
Yes, Lordship. The number is 7955/7.
I'm sorry, Milord, I didn't have the file. Iman,
Of 17, Mohar Ali Sheikh. Mohar Ali Sheikh.
ठीक है, learned concept पता है? They submitted that. They are placing reliance on the division bench judgment of this court rendered in Mohar Ali versus so and so, so and so. I think so it is reported also something.
reported, I think.
However, now they came to know that the bench who has passed the above referred judgment has entertained a review petition in which notices have been issued, and therefore the matter may be taken up after decision of that review petition. Stop. At the request of the learned counsel of the appellant, these matters are deferred till a decision is passed by the coordinate bench in the above referred review petition. Full stop. After delivery of the said decision in the review petition, it is open for the counsel for the appellants to move appropriate application for listing these data fields.
My lord, this is an appeal filed by the department, Corporation Department, Government of Assam. There is some urgency, my lord. Can it be on Monday?
Ask the registry, if urgency is there, they'll list.
I have also made a similar prayer regarding listing of
The same order.
list.
May I please your lordship?
Yes.
May I please your lordship? Your lordship, I beg to list one WA 116/2020.
What I have mentioned to the earlier two councils,
Lordship,
earlier two councils were asked to approach the registry, they will list the matter. Okay? Same.
Delhi list for orders item 1 and 2.
Lordship, I have to obtain instruction. They said it doesn't fall under the litigation policy, Lordship.
Yes, that we have noted earlier.
Lordship, actually, I took time on the last occasion that I awaiting a written instruction. Yesterday, I've been informed by the department that this case doesn't fall under the litigation policy, as because notice was issued and single judge suspended the notice. Thereafter, the department approached this honorable court. Then liberty was granted the department to issue notice by the respondent number 2 and 3. So it doesn't fall under the litigation policy. Lordship may allow to take fresh steps in this case. My learned friend is appearing for respondent number 2 and 3.
What steps you are taking?
Lordship, on the writ appeal, Lordship.
What steps you are required to take?
Lordship, in the service of notice only.
On whom?
On 1, 2 and 3.
You are appearing
I'm for 2 and 3.
And who is one?
One Lordship is a private respondent. He is avoiding the notice, Lordship. Earlier, we took steps by registered post as well as by publishing in newspaper also, Lordship. Then the writ petition, writ appeal was revived. Thereafter, again, we took steps. That was also avoided by him. Lordship, I may allowed to take the steps because he is resident of Panbazar only.
Nikhil and counsel has submitted that he has received the instruction that these two writ appeal, these cases are not covered under the litigation policy of the Union of India. He faced some time to take fresh steps for service of notice upon the respondent number 1, 2, trustee mode. Stop. Requisites be filed within a period of 1 week on filing of the same. Let notices be issued to the respondent number 1 through trustee mode. Returnable 6 weeks thereafter.
Lordship. Much agree.
Item 4.
Respondent number 7, who is respondent number 7?
It's a private respondent, my lord.
His notices have not been received.
No, my lord, it has not been returned also, it has not been received also as per office note of 25 March.
Take fresh steps. The notice issued to the respondent number respondent number 7 has not been received since are awaited since long. Learned counsel for the appellant may take fresh steps for service of notice upon the respondent number 7 through registered AD as well as the mode. Requisite be filed within a period of 1 week on taking some steps. Let notices be issued to the respondent number 7, returnable 6 weeks thereafter.
Wonderful. 1, 2, 3, 4.
Item number 5.
Mr. Counsel, really this writ appeal is still alive?
My lord,
How?
my lord, there is,
Work order is.
no, my lord, there is
All the supply has been done.
No, my lord.
Payment has also been done.
And-
Correct.
another prior was there, my lord, in the writ petition to take, my lord, action as per law against the erring officials that has not been considered. That for, my lord,
Okay. We happy with that.
Apology.
4 and 5. Yes, mister, you are appearing for 4 and 5.
Yes, yes,
You are
Yes, ma'am.
appearing.
yes, ma'am.
Yeah, what do you want to say on this?
Not 4 and 5, ma'am. I'm there for item 5, sir.
You are appearing. The notice to the respondent number 4 and 5 have been issued only on 3rd of March 2025. However, the office has reported that the notices have not been received till date. Let notices of the respondent number 4 and 5 be awaited for 4 more weeks.
Obliged.
I am obliged.
Item 6.
This IA for implement application, my lord. Listed for the first time, my lord. Notice me.
Notice of the IN number 22 returnable. 6 weeks.
For admission, item 8.
Yeah, please, your lordship. Just one paragraph in the Rafik Nasi case, lordship, I want to relax. Just one paragraph.
Which
lordship.
paragraph?
Paragraph 13, lordship.
Of
Well, of Rafik Nasi case, lordship,
Rafiq Nasir.
my lord.
And to you aware, yesterday only the Supreme Court has passed the judgment in the West Bengal teachers case. They have ordered the persons who are appointed since 2016 and remain continue till date. Their appointments were illegal to refund all the salary and everything. We are aware that because they got this appointment on the basis of fraud and misrepresentation.
It was the illegal appointment, lordship.
Yes, this is also illegal. Your continuance is also illegal. Beyond the age of superannuation, your continuation is illegal.
No, that is their lordship, but the authority,
Yeah,
lordship, so far the
Ranjit
authority is
Singhal
concerned.
judge, the Ranjit Singhal judge was very benevolent
My lord,
that against only the concerned block development officer or deputy inspector of schools, they has ordered for initiating disciplinary proceedings. Why against, why not against you?
they have accepted the document, lordship.
Yes, they have accepted. Who has presented that document?
Obviously, lordship, the petitioner.
Then-
appellant. They could have reject that application, lordship.
Yeah.
Well, they could have reject that application. They could not have accepted that.
Yes, they should not have. That's why only they face the disciplinary proceeding.
If they could have accepted, lordship.
Okay, then agree it.
Lordship,
Then be ready for that, that we may order for disciplinary proceedings against him also.
otherwise, lordship, I am ready to do this only.
Then if
Because
you
if-
are ready, then don't argue. And if you are not ready, then come.
Lordship.
Wants to withdraw, on instance wants to withdraw, dismissed as withdrawn.
Lordship.
Item number 9.
Wait, please, your lordship. I pray for timing of the matter. My senior is on his way, your lordship. In short while, short while. I'm grateful, your lordship.
For the timing.
Item 10.
May I please, your lordships? Your lordship, this matter pertains to your lordship, the upholding of the termination order of the appellant, your lordship. Your lordship, the order was passed by the learned single judge on 22/2025, while holding that the contract which I have entered with the school management committee is purely in private nature of contract, your lordship. But however, my stance, yes, your lordship, the agreement which I have entered into, your lordship,
That finding of the learned single judge.
is, your lordship, the agreement which I have entered into is a contract agreement, your lordship, and
That's another thing.
yes, your lordship,
What's the finding of the learned single judge?
yes, your lordship. Your lordship may very well peruse page number 114 of the judgment, your lordship, of the writ appeal, your lordship. Para, your lordship, is at, I'll just take your lordship to para number. Your lordship may very well peruse para number 9, your lordship, of page number 117, your lordship. May I just read?
Read.
Yes, your lordship. The facts of the case as submitted by the learned counsels of for the parties and the pleadings showed that though the petitioner had applied for childcare leave for 4 months in the year 2018, the same had not been granted by the respondents, Your Lordship. The petitioner thereafter applied for childcare leave again from 1/8/2019 to 31/3/2020. That is for a period of 8 months. However, the same was also not granted by the respondents. Despite leave not being granted, the petitioner took unauthorized leave and remained absent from the school till issuance of the dismissal order dated 25/6/2020, which was issued on the 11th month of the absence of the petitioner. Your Lordship may now very well peruse para number 14, Your Lordship. In the case of Gridco Limited and another versus Sadananda Doloy and others, reported in 2012-15 SCC 16, the Apex Court has held that though a writ court is entitled to judicially review the action and determine whether there was any illegality, perversity, and unreasonableness, unfairness, or irrationality with respect to the termination of a contractual engagement, judicial review cannot extend to acting as an appellate authority, sitting in judgment over the decision. The court cannot sit in the armchair of the administrator to decide whether a more reasonable decision or course of action could have been taken in the circumstances. So long as the action taken by the authority is not shown to be vitiated by illegality, perversity, unreasonableness, unfairness, or irrationality, and so long as the action is not demonstratively in outrageous defiance of logic, the writ court would do well to respect the decision under challenge. And therefore, Your Lordship, this order has been passed judgment and order holding that since my contract of agreement had already expired, Your Lordship, there is one issue that I applied for the childcare leave from 1/9/2018 to 31/12/2018. Now, there was a specific order from this honorable court wherein there was a direction to the state respondents to produce instruction as whether the first childcare leave was granted or not. However, that was also not being considered, Your Lordship. And my other grounds of appeal, that since the order is a stigmatic in nature, principles of natural justice ought to have been followed, Your Lordship. Yes, Your Lordship.
Anything else?
Yes, Your Lordship. My other grounds of appeal being, Your Lordship, that I have entered with the school management committee, which was bestowed upon with the responsibility under the scheme, and the school management committee had also received funds from the state respondents to carry out the implementation of this government, Your Lordship. And the contract which I've entered into is a public in nature, and therefore the order being stigmatic in nature after I served for more than 9 years.
Stigmatic order?
Your Lordship, as per the childcare leave that I sought for under the office memorandum issued by Your Lordship, the governor, Your Lordship, there was incumbent, Your Lordship, and the same childcare leave application was.
Once they have not granted the childcare leave, what step you have taken?
Your Lordship, the very first issue is that my first childcare leave was forwarded by the headmaster, whom I had a fallout after this applying of the second child.
The impression that it has been sanctioned.
Yes, Your Lordship, I was told under the bona fide impression and as per the office memorandum.
11 months.
Your Lordship, I had first taken the childcare leave, then again I returned and joined the services. Your Lordship.
When this childcare leave was expired?
Your Lordship, it was the second childcare leave was expired, Your Lordship, after I had joined the first expiry of the first childcare leave.
When? Date.
Yes, Your Lordship, 31/3/2020.
And you have not joined till June 2020 again?
Yes, Your Lordship, the
Was under what impression?
Yes, Your Lordship, at that relevant point of time, the COVID pandemic was at large, Your Lordship, and
That's fine.
so that was the only instruction given to me by my petition appellant, Your Lordship. Yes, Your Lordship. So I pray for issuance of notice in this matter, Your Lordship.
Anything else?
Yes, Your Lordship.
Anything else?
No, Your Lordship. At this stage, Your Lordship, no.
this stage or if you have anything said, because we don't find any other stage in them. This is the last stage.
Yes, Your Lordship.
This is the last stage as per us.
Yes, Your
No
Lordship.
further stage is available to you.
Yes, Your Lordship. And it has also been observed, Your Lordship, that the agreement in itself is a public in nature. And I have also relied upon the judgment of the Honorable Apex Court, wherein there has been a categorization of three kinds of contracts, Your Lordship. And I entered into a public nature contract, so I ought to be governed by the principles of natural justice, Your Lordship. I have already served for more than 9 years. If my first childcare leave was not granted, that is, which had ended in the year 2018,
Okay.
I would have been terminated, Your Lordship. That was not done so.
You were under the impression,
Yes, Your Lord.
okay, since the headmaster has forwarded it and therefore the childcare leave might have been sanctioned.
Yes, Your Lordship.
And even after the expiry of the childcare leave,
I again join, Your Lordship.
you again joined, and but thereafter on second expiry of this leave, due to
No, Your
COVID-
Lordship.
Due to COVID, you were constrained to join there.
There was a fallout before the application of the second childcare leave, Your Lordship.
Okay.
So on that pretext also, Your Lordship,
So your services were terminated on
6, Your Lordship,
25/6/2020.
20. And
When you approached this court, sir,
yes, Your Lordship, in the year 2023, Your
so
Lordship.
what about that? Who prevented you? At that time, COVID was not there.
Yes, Your Lordship, there has also been observation that delay and latches for a period of 2.5.
Yes, what is your explanation for?
Your
that
Lordship,
delay?
I have made approach to the state respondents
By,
by way of either submitting an applications, but however, I also went to the respondents'
Personally.
offices. Yes, Your Lordship, personally, and they said that, yes, you should ought to have been considered, Your Lordship, but on that very pretext, the file was kept on hold, and even this
file
inspector,
was kept on hold. After
Your Lordship, my issue was,
After termination of your contract, which file was kept on hold?
yes, Your Lordship, the whole issue that nobody knew, like whether my childcare leave was granted or not, Your Lordship. Even the director had no understanding whether my childcare leave was granted or not, or even this inspector of schools,
The
but
person who was supposed to grant you the childcare leave, he was also under the impression, pata nahi hua ya nahi hua.
Your Lordship, the inspector of schools had forwarded my childcare leave application to the director,
So
which ought to
forwarded-
have been granted, Your Lordship.
Forwarding means granted.
It had the very office memorandum which says recommended by the headmaster, by the inspector of schools to the director, which shall be granted, Your Lordship. So the headmaster in the first childcare leave had
Once
conveyed to me.
recommendation is there, granted.
Your Lordship, the headmaster had conveyed that your first childcare leave has been granted. So that is the whole information, Your Lordship, and as per the instructions, Your Lordship.
Because
And Your Lordship, the other issue is that, Your Lordship, as per the clause 9 of the agreement, Your Lordship, there is a particular clause that if the party is found to be guilty, Your Lordship, then it is imperative to provide an opportunity, which I have taken as a ground for appeal, Your Lordship. So there has to be some determination. There was a resolution by the School Management Development Committee that I was not being made a privy to it, Your Lordship. And I have served for more than 9 years, Your Lordship. So, and the order being stigmatic at the last end of my career, so the principles of natural justice ought to have been followed, Your Lordship. So these are my humble grounds of appeal, Your Lordship.
close for orders.
Yes, Your Lordship. Much obliged, Your Lordship.
Item 11.
May I please, Your Lordships? May I please, Your Lordship? May I just submit 2 of the judgments of the Honorable Apex?
Most welcome.
Much obliged, Your Lordship.
Give it now. Now.
Yes, Your Lordship.
Yeah, please.
Item 11.
Well, in this case, I'm challenging the order dated 7/12/2023, which is at page number 17, my lord. Yes. By which, my lord, the learned single, the. Which for the, you are from the private school?
It's not.
Yes. Has directed to provincialize the service of the respondents under an act which, Act of 2011, which has already been struck down, my lord. And that's why the issue is whether whether the service of the writ petitioner can be provincialized. Yes.
My lord. What my submission would be, my lord, today. If my lord, this private respondent doesn't want to file reply, my lord, then let this matter be after vacation.
Choice.
Yes, my lord.
Doesn't want to file the prayer. Is it choice? Argue it out.
Then my lord, kindly adjourn this matter, my lord. I'll address properly, my lord. Because I will rely on some judgments also, my lord, because the settled proposition law is that,
Rely.
my lord, I am not prepared today, my lord. Because settled proposition of law, my lord, is that when an act is declared to be, my lord, unconstitutional or repealed, it has to be considered as if it had never existed, which is relied upon in Surja Kumar Okram case, my lord. And then, my lord, another ground, my lord, which I am, my lord, relying that the prospective overruling can be applied by the Supreme Court only, my lord. And since, my lord, this 2011 Act has already been struck down, technically it is not possible today to grant relief to the petition, my lord, respondent under this struck down Act, my lord. And rightly, my lord, the department has provincialized the service of the respondent under the 2017 Act, my lord.
Judgments.
My lord, as I have already said, my lord, today I am not prepared, my lord. I could not bring the.
Young advocate. Yeah. Don't you know the habit of the court?
Yes.
Often we are hearing the matters at admission stage itself.
I'm sorry, my lord.
What do you want to say, Mr.?
May I please, your lordship, my lord. This order which my friend is challenging, it's culminated from this order 19 to 2015, which was a consent order, my lord.
Right.
It was,
Yes.
it was a consent order. And they wrongly provincialized the services of two gentlemen who were 16 years junior to me.
That may not create any right in your favor.
Yes, my lord. But ultimately,
If they wrongly provincialized services of someone else, you can't claim the equity with them since it is wrong.
another thing is, no, my lord, under the Provincialization Act of 2011, even the subsequent act, the person, if the two posts were supposed to be taken and if there were 3 or 4 members, senior most persons has to be considered. Over there, what they have done, junior most 2 persons they have taken. We approached this honorable court. This honorable court, after they get the information and they get the instruction, they inform the court. There is a post lying vacant against which.
The question is, once this act of 2011 was declared as void, what benefits you can get out of that legislation? This is the main question. So let us know, argue it on this point.
My lord, the only thing is that cause of action as well as the right accrued before the act was declared ultra virus.
But
And
it was declared ultra virus, then everything which you acquired or anybody has acquired, that is gone.
my lord, over here in this case, what happens after the declaration of the ultra virus, it was supposed to be that all the provincialization also goes.
Yes.
What the state has done, they filed a review petition.
Yeah.
And they have saved the persons who accrued the right, my lord.
Where is that?
My lord, that review application petition is not here, my lord. That's all judgment.
Review judgment.
Yes,
But
my
the
lord.
learned single judge just quoted it.
Yes, my lord.
Para number 8 of the impugned judgment.
Yes, my lord.
Read.
That is in 19.
Read.
Para 8.
Para 8.
Secondly, we also take note that the Act of 2011 was declared ultra virus by the judgment of the division bench rendered in Chandan Kumar Niyog and others versus State of Assam and others reported in so and so. But against the said judgment, a review was also instituted before the same bench, being review petition number so and so, which was decided on so and reported as so and so. In paragraph 19 of the review judgment in State of Assam versus Bimal Kutum and others, it provided as extracted. In the above circumstances, we are of the considered view that the rights of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decides.
So if the legislature has taken, has took any decision,
Yes,
where is that?
in the new act.
Read. They left it for the legislature to take a decision.
2017 act was Assam.
My lord, this review says that
We will ask you, then only speak. So now, Counsel, the learned single judge has relied upon this review that in the above circumstances, the employee who have benefited struck down can be can be taken care by the retrospective effect of proposed legislature so decides. So it was left open for the legislature to take a decision on it. Now, what the learned single judge has said in para number 10 of the impugned judgment, come.
In other words,
Para number 10, yes, in other words.
in other words, the court which had declared the act of 2011 to be ultra virus upon review had also clarified that the legal right of the employees which had crystallized under the act of 2011 are to be protected, and the principle of retrospective effect of it became void had not been accepted.
The learned single judge has never said that this review judgment never says that are to be protected. They say if the government thinks so, they can give this effect, retrospective effect to this. But if the government has not given, that doesn't mean that this review judgment, on the basis of this review judgment, their services are liable to be provincialized. That finding of the learned single judge is not sustainable.
My lord, to my knowledge, my lord, after the review petition, after the review application was decided by the division bench, similar and lots of incumbents under similar circumstances, they were given the protection and their services were provincialized.
Your information, please substantiate your information by producing
But,
documents or something else. Substantiate your information. Seems you are not,
I'll do it, my lord.
you are not fully prepared.
No, my lord, this point which my lord has put in across, I was not prepared.
Then across the, if we, something came in our mind, we are supposed to disclose it to you, otherwise how will you defend your case?
Yes, my lord, I'll prepare myself in that ground and come back.
Mr. Counsel, you may also prepare and come with these judgments and be ready with this court.
yes, sir.
Matter can be taken up at any stage.
Yes.
Don't wait for this hearing category and all. Monday, come prepared. Judgment under.
My lord, would it be possible on Tuesday?
Not Tuesday, Monday. Tuesday is the hearing day. Okay, Tuesday. Come on Tuesday.
Quickly, please.
Tuesday. The request of the consulted party, this matter on Tuesday get it.
Item 13.
As far matter has been interfered with, and your lordship has protected by an interim order. So matter has now the appellant is serving in the transferred place. Well, about 39 persons were transferred. And the Rani Singh just said the reason is not good. 39%, well, interim order, your lordship has recorded for all my submissions. I can give 3 judgments, my lord, your lordship may. Well, I've given 3 judgments of the apex court, my lord, when the transfer order is liable to be interfered with. As many as 39 were transferred.
My lords,
The state has not filed any appeal against the interim.
we abided by the single judge's direction and issued the consequence orders, my lords. Because we tried to defend, we took as many as grounds we could, my lord, but everything was not entered, anything was not entered by this internal single judge, my lords.
You are filing appeals on very frivolous ground. Here you have not filed it.
The department, my lord, because it could disturb its chain, so everybody was satisfied, we didn't prefer any appeal, my lord.
Very strange.
My lords.
You have what?
I'm for the repetition.
Where you are working now?
Presently, my lord, in the transport place, my lord.
Transport place. Enjoying.
No, my lord.
Why?
Because for the,
It is also a border area.
my lord.
It is also a border area.
What if I kindly tell you the stand of the affiliate in the affidavit? In the petition, we file affidavit, my lord. There stand is that, my lord, there also affected by the frequent transfer. In 3 years, they will transfer from four occasions. Like the petitioner.
Only in Assam,
My lord,
only in the state of Assam,
my lord.
or somewhere in other states.
So they are not.
What remains?
They are accepted, but they cannot be transferred after that.
Transfer in the incident of service.
Yes, but cannot be said, transferred like anything, my lord. They have
Right.
been transferred within a period of 3 months, 4 months.
Always open. Always open.
That is malafide.
That is
not,
malafide.
that cannot be termed as public interest.
That is malafide.
Yes, that cannot be termed as
It requires some consideration. Admit having heard the concept of the party. There are no views. As deem it appropriate to admit this petition. Admit no need to issue notice to the respondents as they are represented to respective concepts. This for the hearing, the month of August.
that we document, give a short date, so that this can be disposed of.
Short date,
Transfer letter,
it's better.
after 4 months.
Item 14.
It's a short date, only thing,
Yes,
it's short date, will be given back.
August. Better.
Okay, and this item, a reply has been filed recently on 17th. I got a copy on 19th. They have now annexed 2 additional documents which are not earlier part of the writ proceedings, my lord. So I would like to file a short reply, my lord.
How can we help you until and unless to challenge that rule itself?
My lord, the rule is not a rule, my lord. Here it was a instruction only, executive instruction,
Whatever it may be, their whole organization going on these instructions only.
my lord. But in that
Because
rule,
in the absence of any rules, the instructions are.
my lord,
uh,
what we stated that in 2016, the Meghalaya High Court had already read down that rule.
That is not.
There's a judgment that is also annexed, my lord. They say that the ARA duty is also part of the same
But
organization,
you yourself have opted for this posting, sir,
my lord.
knowingly that your tenure at that, whatever the.
So the extended tenure, my lord, in
is
respect
not
of,
supposed to be taken into consideration for the purpose of promotion.
my lord.
In that Meghalaya case, he was sent on, say, by the department.
No, this thing that they are saying that I had made a verbal request, my lord, is their statement, my lord. They say that there's no request as such.
You have not
They say that
doubted it.
I
You
have
not
made a verbal
doubted it
request,
Before the learned single judge, that you went on that posting
my lord.
as per your choice. Or as per on your own request.
Yes, the
You have
first,
not counted that.
the first request was there. That was only for 2 years, my lord. In that case, I would have still earned 3 ACRs from the unit, my lord.
But
But then I was not given a reliever.
their case is that despite the time was over or 2 years or whatever it may be, you have not reported back to the.
I
you
was-
did there. On
I
your
don't
own
report back
volition.
on my choice, my lord. Some reliever has to be given, my lord. I cannot report back to the unit by my choice, my lord. I don't control my posting, my lord.
And
Unless and until somebody else is posted, I cannot just abandon my post and go back to the unit.
There's some time to file counter to the affidavit in opposition filed on behalf of the respondents. Time period is after 6 weeks.
Obliged, sir.
Item 15.
May I please, okay. Actually, this is the case where my account has been freeze actually on the pretext that
Any responses filed on it? Yeah.
what happened that Lordship, they had filed an affidavit in opposition. The same matter, they only underlying one sentence is that since it is a continuing guarantee, that everywhere actually. But here it is, the fact is that it is a specific guarantee. And if I come in details of my lordship, if I come in the contract acts also, there also I am relieved. Because if it is if agreed but not accepted, if it is a continuing guarantee also, then section 62 and section 133 of the contract acts comes to my relief.
You have to find a counter to this because your case is that you have only this this place or whatever it needs NSC certificate. They're saying the FDR was also placed.
NSC has been placed.
NSC as well as the FDR, both.
Okay, what they said actually.
So you have not gone through the.
I have, your lordship, I could like to say I have gone through it. But this, the thing is that fixed deposit was created much more later time actually.
Sir, please come to this internal page 5 or 43 of this paper book. It is pertinent to mention.
That herein that in Simon substance of the matter and its entirely the facts leading to the case matter was initially on 27/2/6 cash credit loan facility was granted for an amount of rupees 10 lakhs with pledge of NSC of rupees 2,08,000. Thereafter, the loan facility was enhanced to 20 lakhs on 28/1/2028 with a lien of FDR of rupees 2 lakhs. That is correct. That is not my 2 lakhs. That is my husband's 2 lakhs. That one was.
Come on, read whole para.
I'm sorry, my love. I'm sorry. With a pledge of NSC of 2,08,000 and subsequently the loan was enhanced to rupees 40 lakhs with a pledge of NSC of rupees 2,08,000 along with an additional personal guarantee of Mr. Raj Jyoti Changakati. Thereafter, on 23/11/2011, the said facility was renewed with a lien of rupees FDR of rupees 3,36,230 and NSC of rupees 35,000. And lastly, the loan was restructured on 31/2019, which the facility amount in a cascade as rupees shown. What I assume is that my lords have been targeting this 23/11/2011 part where the FDR was 3,36,000. Am I in the option?
Read whole para.
Okay, I will say. And lastly, the loan facility was restructured on 31/2019 with the facility amount in cash credit of rupees 70 lakhs and WCTL amount of rupees 5 lakhs to the pledge of NSC and FDR amount was credited to the saving account of the petitioner. Hence, the freezing of account cannot be released and continuing guarantee as well. in here it says here the 2011 matter of 3,36,000 and 35,000, which has been liquidated and put into my account. Lordship,
If you wish to file any counter to this.
counter affidavit, I should file.
Counter-
I do agree.
Otherwise, we.
I do agree. I do agree. I do.
Yeah, then consider the
Rejoinder.
petitioner prays for granted time to file counter to the affidavit in a petition filed on behalf of the respondent. 1 and 2. This after 4 weeks.
Oblige, Your Lordship.
Pass over matter 9.
Okay.
My lord, I apologize for being not present when the matter was called, my lord. I was on legs in another court.
Mr. Chaudhary on 9/9/2020.
Yes, my lord. That instruction I had, my lord, on the last occasion I prayed for time because voluminous records. That's why, my lord, records have come, my lord. May I place this record? My lord, the witness was, my lord, present on behalf of the bank, and my lord, he was allowed to be cross-examined. Those are there on the record, my lord.
That's a place on record the statement of the witness
My lord.
recorded in cross examination. Place on record.
No, this, I thought your worship will peruse the records, my lord, and that's why I thought.
Place on record that affidavit.
Then by an affidavit will file.
Concept for the fact that has submitted that he is in receipt of the record. And as per the same, a witness was produced on behalf of the
Bank.
department, and he was also cross-examined by the
Delinquent.
respondent.
Delinquent, my lord, respondents, delinquent has died, my lord.
Delinquent. He takes some time to produce the copy of the statement of the witness recorded during the course of disciplinary proceedings. Statement of the said witnesses witness recorded during the course of during the disciplinary proceedings. Time period for his granted.
2 weeks, my lord.
Just after 2 weeks.
Obliged.
For hearing, item 25.
With Lordship kindly pass over the matter for time being, Lordship.
This is the only last matter, ma'am.
Then Lordship, for a day, Lordship, pass over the matter for a day.
at the request of land consent for the petitioner adjourn. This is in the month of June.